Welcome to Community Empowerment. I'm Roberta Martin, your host and your interviewer. Tonight we'll be talking about family court system, its structure, and how it operates. Tonight I have with me two judges with knowledgeable background in family court systems. With me it's Christian Sande of 4th Judicial District and Michael Browne, also of 4th Judicial District. Gentlemen, you're welcome.
Thank you.
Thank you.
So I want us to just look at the family court system. I know that people have some misconception about how the courts run and how the court operates. And so I thought that it would be wise for us tonight to just look at the structure of the family court and how it operates. So why don't we just start with you, Mr. Sande, giving a little brief explanation about yourself, what you do, and then Mr. Michael will take it from there.
Okay. I was appointed to the court in June of 2016. I served for about 9 months in Hennepin County Criminal Court and then moved over to family court where I've been for about a year. Prior to my appointment to the bench, I was a lawyer in private practice and I handled mainly class actions and securities fraud cases. I was also chair of the State Campaign Finance Board.
Thank you.
I was appointed 3 years ago.
Yeah.
And when I came on board, I was originally in the criminal division, and I moved to the civil division. So I was in the civil division for 2 years, handling civil cases of all varieties and also criminal cases at Brookdale before coming to family court. Prior to being appointed and then elected to the bench, I was at the Minneapolis Department of Civil Rights, and I was the director of the Office of Police Conduct Review. And so I've spent basically the last 10 years prior to being appointed in civil rights and human rights type of work. I also worked at the State Human Rights Department.
Thank you very much. Beautiful background. Before we start going into the discussion tonight, I want us to first of all look at this question. Who decides who becomes a family court judge?
It is, well, the governor decides who to appoint, unless there are times when there might be a seat open, at which point there'd be an election for the seat. So the governor appoints people to the bench. The way that our assignments work to the different courts is through our chief judge and our executive committee, which Judge Browne is on that. He could probably answer better than I can about how the judges are given their different assignments. It's partly on seniority, isn't it, Michael?
Well, the way that our system is set up, it gives the authority to the chief judge to determine what is the assignment for the particular bench needs. So typically what the chief judge will do is look and see where are the needs and then look at the judges who have already done assignments in specialty courts, and then those who need to do assignments in specialty courts. And so in our system, all the judges will rotate through a specialty court, and family court is considered to be a specialty court because our goal is to try to problem solve. That's the main objective, and that's what our focus is, and it gives a judge an opportunity to work specifically on problem solving.
Thank you. Let's begin by looking at the structure of the family court system. So my first question is, and Mr. Michael, you can take this one. So explain the Hennepin County court system, the Housing Conciliation Court, its structure. How is it structured?
Housing and Conciliation Court. So Housing Court, Conciliation Court really fall under civil court. So there's a lot of subdivisions in each larger group, and that would fall under civil. And so civil housing court, mainly those cases are going to be heard by referees, and those are lawyers who are appointed to hear cases. They're considered to be judicial officers, so they can make decisions on the cases, but they're not appointed by the governor and they're not elected. In conciliation court, it's quite similar. That's where you're going to hear initially claims. Usually those claims are going to be lower in dollar value. Some claims where you're trying to get property back can go to conciliation court, but all of those cases are going to be heard by referees again. So those are people who are lawyers who are hired to come in and hear the cases. We do that because of the volume. There's a lot of cases that go through there. And an individual can decide if they don't like that decision, they can appeal it to a district court judge, and that's how you'll end up in civil court.
Mr. Sande, you want to add something to that?
Well, for an overall view, I think for viewers to understand is how the court is kind of divided up into criminal and civil, and then subdivisions from there. So criminal would be anything involving a crime prosecuted by the state or the county or the city, depending on what level it's at. So Judge Browne also had a rotation in criminal court, more than I did, more substantive also in this part of the community. So I think he can answer how those cases come through. On the other side is then civil. And under civil, you could say that family law is a part of that. We've created a family court because there's so many cases that we have a special, it's not under family or under civil, but it stems from civil law. We also have the juvenile courts, which again might be more related to criminal, not exactly. There might be some civil cases that come in, but the four main types of courts that we have in Hennepin County are criminal, civil, juvenile, and family. And so a lot of times what Judge Browne and I then confront every day in family court is people who are arguing that we're going to take away their kids, and it's like, this is not a juvenile proceeding. The state is not involved in this. This is a dispute between private parties, a couple, married couple, something like that, just like in civil court, where in civil court is a dispute between private parties. Now the state may be a party to that, but there is not a violation of the law being alleged. There's not a law that's being broken, that someone's going to go to jail, lose their rights, something like that. So the key for people to understand is if you're looking at the four main courts in Hennepin County, it's going to be criminal, civil, juvenile, and family.
So I know you guys have already touched on the family system, but can we just really get a clear picture of where family and juvenile sit in all these structures that you mentioned?
Can you explain the background of that? And again, the reason I defer to Judge Browne on a lot of these because he's on the executive committee and he's got more seniority than me, but I think he has a better overview of the way that the court organizes juvenile and criminal, or juvenile and family. And I think a lot of people end up feeling like they're coming into family and they feel like it's a juvenile proceeding. It really is not.
Because I'm thinking right now, what is flashing in my head as you guys were explaining is I'm looking at suppose a family woman like me with a kid come to court, but the issue has nothing to do with criminality. Therefore, there's no need for me to go to a juvenile section, but then I have to go to family. Is that the understanding there?
So here's the interesting thing about that. One of the things that can happen is that you can have, let's call it a single incident. Okay, so an event happened, and it might touch on a number of different courts that we have, because what we would do is we would put them in different categories. So it's conceivable that you would have an incident that could be criminal in nature. Okay, so domestic violence would be a good example of that. It could be criminal in nature. You could end up in family court because somebody could be asking for an order for protection, and that would come through family court. You could also be getting a dissolution, or that could result as one person files for divorce, and at the same time there may be some civil issues that are related to it. So maybe there's some damage to property, and you could find yourself in conciliation court, or also in civil court. And if there's an apartment involved, and as a result of that displacement of family members and the rent can't get paid, the family could find itself in housing court with an unlawful detainer. So one single incident really could stretch an individual or a family across a lot of sections in district court.
Wow, that's very an in-depth, I never knew it was like that. So you can come up, I'm sorry.
We try to communicate with each other about that.
Right.
There's 62 judges in Hennepin County, but we're all within a vicinity of one another, and because of the technology that we now have, we generally know what's going on with different cases. And so if I know that someone is going to be appearing in a criminal matter, I can get ahead of that by scheduling my family court case not at that same time. Or I've even had it where we had someone that was appearing in family court who actually had a warrant out for their arrest, and in that case, we would contact the criminal court and let the person know, you need to get this taken care of. In some cases, they may be taken into arrest for the warrant, but not necessarily. In other cases, if it's a low-level matter, I can contact the criminal court and say, I've got this individual in my courtroom, there's a warrant out for their arrest, how about if I quash the warrant and can we get them a new date to come to a different courthouse to deal with that? So it sounds like the people could be in a lot of different areas, but we do try to communicate regularly. A lot of that is the work of the courtroom technology. When someone's in my courtroom, I generally know if there's a warrant out, if they have an order for protection involving them, what their other court appearances are, so we try to not give them a runaround, but sometimes, as Judge Browne said, it can be involving a lot of different laws, and that's just how it goes.
So a typical example can be a person just can walk in court and have a problem involving a child, housing, maybe something criminal, but that person will be going to all these varieties of places. Is that what that means? So you end up going to a criminal court, you end up going to some reconciliation court, and you are this one person.
It would be an extreme example to have that happen, but it certainly does come about. Again, we try to coordinate that to make it easier for people to address that.
So maybe another example of how someone can end up in many different courthouses. So the one person happens quite often, quite frankly, in the criminal context. So let's use the scenario where somebody has lost their license. Now, there's lots of reasons why somebody's license might be suspended.
Right.
But we'll just start with the premise that the person has lost their license, but they continue to drive. So if they live in Brooklyn Park, but they work in Bloomington, they're going to cross a lot of jurisdictions to get there. And if they're in the unfortunate circumstance of being stopped and receiving a lot of driving after suspension tickets, you could find yourself having to make appearances in downtown Minneapolis. You could find yourself having to make appearances in Ridgedale or in Brookdale. And so in that context, you have one individual who has multiple court hearings. And one of the things, again, as Judge Sande was talking about, we can see that this person has multiple hearings that they need to be at, and we can coordinate. And sometimes we can even sort of put some of them together so the person can come in and make one appearance for all of the hearings. But that would be an example of why somebody might find themselves at different courthouses in the county with a similar issue, and it happens a lot in the criminal context.
Thank you very much. Mr. Sande, would you give me some examples of cases that come to the family court? I want us to just shift to concentrate now on the Hennepin County court system. So what are some of the typical cases that you see?
Well, if you ask what I spend most of my time on, it's going to be divorce cases, or cases where it's involving custody and parenting time for a child. That would be a situation that they don't have to be married. If they have a child together, then they have, the parents have a right to have custody and parenting time with their child. If they can't reach an agreement on their own, then they might come to court and ask us to help them with that dispute. We also hear orders for protection involving domestic violence. Now, an order for protection is, again, a civil matter between two parties. What happens is the court will, someone may, if they feel like they are threatened or a victim of domestic abuse, they can petition the family court for an order for protection. We would then review the petition, decide if we would grant it, decide if there needs to be a hearing. And at that point, if we issue the order for protection, it goes to law enforcement, and the person then can feel safe at home. If the individual contacts them, they can call law enforcement. Law enforcement will then know that we've issued the order. So the main things that I see in my court are generally divorce cases where we're helping people get through a divorce, divide up the assets, figure out how they're going to raise the children together even though they're no longer married. Custody and parenting time where they were never married but they need to raise the kids together. And orders for protection. There's other family type cases, but really those are the ones that take up, I think, most of our time, don't you think?
Well, 24% of the cases that we're going to see are going to be dissolution cases with children. So then if you add another 8% of the cases that we see are going to be custody cases, we're primarily looking at cases that deal with children. Right. Plus the paternity cases, another 16%. So we're looking at a large percentage of cases that in one way, shape, or another, there's a child involved. And so one of the things that we work with a lot is what we call the best interest of the child factors. And this is a 12-factor test that's laid out in the law that we use to determine, okay, what is really the best course of action that's going to keep the child or the children safe, healthy, prosperous, educated. And so this is it's a very involved process to make sure that we are focused on the children.
So what I'm hearing is it looks as if divorce is the major thing that you mostly handle daily basis.
It's either divorce or it's involving custody of the children. But as Judge Browne said, it's not that often that we're just dividing up money. You would think that family court would be more about dividing up who has to pay somebody else. That's not as often as you'd think. The cases that really take up most of our time are kids, and it may be a divorce, and then we decide that. But it's two parents or family members who have had to step in when one or both of the parents aren't able to take care of the kid, and it's always focused on the best interests of the child. So people come in and they want to make their arguments about themselves, and we end up having to steer them to, no, this is about the kids.
Right.
Tell me about the kids. Tell me why we should be focused on one parent or another and how we would handle those things. The legislature has made it very clear that the focus of our proceedings involving children has to be the best interest of the child.
With that said, I like to just say this. You hear this typical words in people. You might not hear it, in your court system, but you might hear it in a kitchen table. You might hear it in a parking lot after church, or you might hear it, in classrooms and things like that. The judge is getting ready to take my kids from me. Does judges have the right, or do they have the right to take any child from anybody?
Michael?
Well, I mean, yes, but
and
it depends. And
Tell
it
us.
depends on the context, right? So, again, we're going back and we're looking at best interest of the child.
Absolutely.
And so, not only, and I like to explain this situation we're talking about children in the sense of there being sort of a triangle of parenting. So, the best parents are the ones that know the child. Okay, we're talking about mom and dad, right?
Absolutely.
That's who we're talking about.
Right.
It is the parents. But oftentimes the parents get stuck. And sometimes it's through issues like chemical dependency issues. Okay. Well, in that scenario, that individual may feel like the child's being taken away, but really what we're doing is prioritizing what's in the child's best interest. And it might be for that particular scenario, that's not in the child's best interest to be with a parent who has a chemical dependency issue that hasn't been appropriately addressed.
Right.
And with that case, we may decide, well, it's in the child's best interest to be with the other parent for that time being. And so there are definitely scenarios where we're going to be looking at the whole field of issues. And sometimes I think that it gets looked at as a perspective of something being taken away, because it's going to feel like that.
Mr. Sande, if a person come in front of you in court and they are couples, okay, I'm giving you a scenario. So a woman and a man with 2 kids, and they don't want to get married anymore. And the woman is saying, I want the kid. And the man is battling, I want the child too. What would you be expecting from both of them? what will be some of the expected things that you want to hear from them to determine who have the kid?
Well, we're guided by the law. You know, I always tell people, like, I don't make the law, I just apply the facts to the law.
Right.
So, you know, if someone is unhappy with the way that the law is currently, they need to deal with it through the legislature through another means, or could maybe take a decision of mine up on appeal. But what I'm interested in hearing from the parents, again, is what is in the best interest of the child that they think. And I can give them specific factors. Mm-hmm. If we're going to set it out for a hearing, I will photocopy the statute and give it to them. Right. Say, okay, when we have a hearing, these are the 12 things I want you to tell me about. Right. And I want you to answer this for me. I'm always very clear to tell people that in Hennepin County Family Court, we don't take away people's kids. Mm. Now, juvenile court, there's a specific process where parental rights can be terminated. Everyone's represented by a lawyer. There's a process for it, and it's a very, very severe process that it goes through to terminate some of the parental rights. In family court, Judge Browne is absolutely right. There might be a situation where a parent, being with the child is not and being with a parent is not in the child's best interest. Right. But then we can set conditions and say, okay, I want you to show me drug tests to show that you're no longer using drugs, and if you show me that, then we can increase the time that you see your child. Or maybe if there is abuse between the mother and the father, we can say, okay, then mother and father aren't responsible for trading the children anymore. You go to grandmother's house or you go to a supervised place. What I'm interested in hearing from the people who are in front of me is what's going on in their life, what are their plans, what do they know about the kids. If I have someone, particularly it's usually if it's a third party, like a grandmother or an aunt or something like that who's coming in, and usually they are asking for custody of a child because the parents are having a real tough time. Mm-hmm. They may be they may have disappeared due to an opioid addiction. Mm-hmm. They may be incarcerated and all that. And in that situation, someone isn't really fighting the person for custody. But I might ask them things like, tell me about your grandson. What's his favorite food? Mm-hmm. What time does he get up in the morning? And all that. And then that's what I want to know, is I want to know how well do they know the child? What are they doing to be involved in the child's life? And you try to get people to engage you and tell you these things. But it's key to set out that if I'm going to set restrictions on where they see their child, I'm going to give them a path that they know to go down, that they will have, hopefully, the exact type of parenting time that they want. Like I said, if they've got drug addiction, if they have unstable housing, if they have a history of domestic abuse, I want to know, are they getting therapy for that, so that we've got a path for them to get back there again. I want to hear from them. Why do they think it's in the best interest of their child for the child to be with them?
And let me just add to that.
So of course.
Some of the things that Judge Sande is raising,
yes,
these are all things that we can order. So this is all within the scope of the authority of the judge to order UAs if that's an issue, to order that people go and take co-parenting classes, mm-hmm. if communication between the parents is at issue, if that's the number one challenge that's creating the conflict. Because first of all, the conflict is not good for the children. Conflict is not good for the children. When the child is worried about the conflict between the parents, that child is an additional burden when it comes to focusing at school, getting homework done, being involved in activities, building relationships with friends. All of these things that are important for children to be focused on and to be developing, it becomes disrupted when the parents are in conflict, because they absorb that conflict. Mm-hmm. Secondly, the children need to have stability. That's how children thrive, having stability and consistency. So ordering a parenting time schedule doesn't mean, for example, that there's a good parent and a bad parent. That's not what it means. It means this is what's in the child's best interest, is to have a consistent schedule that the child can rely upon.
In this case, do you involve the children in the decision making and say, would you want to stay with mom or would you want to stay with dad?
I think that's a great question. So one of the factors in the best interest of the child analysis is input from the child if the child can appropriately provide that input. And typically the way that I have seen that done in my court has been through a guardian. So we wouldn't typically bring a child in and say, okay, you know, which parent do you want to go with? We wouldn't put the child in that position. No, absolutely not, because again, that adds to the stress that the child is feeling, and anything that's bringing the parents into court is creating stress between the parents. It's also creating the stress on the child. So we wouldn't put a child in that position. Yeah.
Thank you very much.
I don't. It's. I'm with Judge Browne that people always want us to listen to their child, and I always tell them, like, you know, the child isn't a party to this case,
right?
And it's between the parents, and the parents are responsible for raising the child. If the child is a teenager, they might be old enough that we can find out, but that is one factor of the 12. So it's not going to be overriding.
Right.
At the same time, you know, if you've got parents fighting over a 16 or a 17-year-old, it's like, look, how are you going to get the kid to do what I tell them to do anyway? I mean, I don't have any jurisdiction over the kid.
Absolutely.
I can't issue an order for the kid.
Right.
But when I've used it successfully, is if two parents they're having their own disagreement, and sometimes they're getting caught up in their own argument. Yeah. And they're both saying what the child wants. What we might do is use someone from Hennepin County Family Court Services or a guardian, and they'll visit with the child. And in one case, what happened was a father believed that the mother was preventing the child from coming to see him on the schedule that they've had for this girl who was, I believe, 15 or 16 years old. The schedule they'd had since she was 8. And what the person that I asked to interview the child, what she came back and said is, like, she just wants to sleep in her own bed now. She's 16. You know, she doesn't want to go over to her dad's house every other weekend anymore.
Right.
She's a teenager. She wants to be around her friends.
Right.
But they actually gave great feedback where they said that what she really wants is to have a few nights a week to go out to dinner with her dad, or make a dinner together, do a project, go to a movie. Right. And those are things that's how we can do it. But immediately, if right away at the first hearing, someone comes in and says, you know, I've got a letter from my child, or they want to be here and all that, it's like, you cannot delegate this dispute to your child. Right. This is a teaching moment for you as a parent to teach the child that you have to deal with your own problems yourself, and that also you have to follow court orders, even if you don't necessarily agree with them. Right. So you have to find a way to work your way through it.
So, go ahead.
Yeah, well, I wanted to add to something that Judge Sande is saying, because he is talking about an issue that I agree with him on. This is a teaching moment. Yes. And one of the things that I have seen, particularly with parents that have children that are older, so now we're talking about the 15, the 16, even the 17-year-old, is this idea of letting that child be a part of that decision-making process. And one of the things that is helpful to remind the parents is not to abdicate their responsibility and their role as the parents, and they still need to make the decision. Even if the child is 17, you still have to make the decision for the child. And the decision should be made between the parents. And if the parents can't make that decision, they have to come to court and they get help from us, and we will help resolve that dispute or make the decision for them. And oftentimes you will see this dispute come from whether or not the children should be able to go on school sponsored trips, or whether or not they get a passport, or whether or not they get to go to one high school versus another high school. And sometimes these are tough decisions that parents get stuck in, and I don't think there's anything wrong with the parents getting stuck in those decisions. I think the key is to not abdicate it. Still have to stay engaged and be the parent, and if you can't reach an agreement, to come back to court so that we can help the parents get through. Yeah.
These are some very tough things,
Yeah.
particularly when they reach the age of 16, 17, 18, because then now they feel like they can make the decisions themselves. And I think I have also seen a case where the child tried to create enmity between the parent, you know, and the child would just, because the child wants his own way, you know, at 17, they want to do what they want to do. And so then they tend to be on mom's side a little bit, particularly if they divorce, because they share, you know, they share the parent. They go here to dad house certain times, come to mom house certain times, and they go say certain things over here and say certain things over here.
Yeah.
And they are in the center of the
Right.
confusion.
Right.
But that requires the parents communicating with one another.
Absolutely.
And as Judge Browne said, there are classes that we can order parents to go to learn to deal with their conflicts. The one thing that I can always get parents to agree upon when they're raising a teenager and they're in family court, I can always get them to agree that a child who feels like they can play one parent against the other will do it.
Right.
You know, and then I say, look, this kid is going to play both sides against the middle if you keep letting them do it. And they both nod. And it's like, well, then you need to communicate with each other. You know, if a teenager can tell one parent, I'm going to go over to see the other parent, and then go off with their friends. You know, the parents
Right.
have to be able to communicate with each other.
Right.
But as Judge Browne said, there are an awful lot of tools we have that we can inform people about. And at the end of the day, if the level of conflict is high enough, we'll just order them to do it because it will get the child out of this dispute and get the parents to focus on dealing with that dispute.
Let me
Sure,
add one
yes.
more point to
Absolutely.
To this particular topic. The communication is such an important piece of this, and oftentimes if you're dealing with a situation where the parents used to be spouses, okay, there was a method of communication, and they've probably developed that method of communication over a very long period of time. Now, if the parents aren't spouses anymore, there's a different method of communication that needs to be used.
Absolutely.
And you need to give time to be able to develop that method just as the communication was developed in the marriage. Because the co-parenting language is much different than the language between a married couple. And that's why
That's amazing.
yeah, that's why sometimes some of the conflict and some of the disputes that come back really are the symptom is the dispute. And the true problem, the true issue, the underlying issue, if you were to go a little bit deeper, was the language used to communicate the idea. And that's why it's so important when you're dealing with children for the parents to learn a co-parenting language.
So that's why you were saying something about it's a learning moment. You learn almost the whole spectrum of the child's life.
Well, that's
Right,
why I
because-
like family court. It never gets
Very
dull.
interesting.
There's always new things and new tools that you can use to address these issues.
You know, you two mentioned that in a situation where you realize that one party is having a problem with maybe alcohol or drugs or something, you send them to certain places so they can get help. Has there been a situation where you send somebody to go get this kind of anger management problem, help, and they just will not go?
Oh, yes. Well, keep in mind that this is, like I said, a civil court. The only way that I can force someone to go to that is it's a carrot and stick. I can say, if you want to see your child again, you have to do these things.
Right.
If you don't do these things, the only thing I can do is say that I'm not going to allow you to see the child. Criminal court, the sentences that Judge Browne issued, if you don't do this, we're going to lock you up. I can't lock people up.
Right.
That absolutely comes
Yeah,
up.
yeah.
Well, because that's probably, a topic for a different show, but the problem of chemical abuse and just
Right.
people will make promises and it's just very, very difficult to get beyond it. The same thing with cycle of domestic abuse. There is a long path for people to go down to deal with that.
I'd like us to shift to domestic abuse and talk a little bit about that. But before we do that, I'd like to chip in a little bit about culture in here. I know this is, the Twin City is getting very diverse, right? We have people from African continent, different parts of the world, right? And they all come with a different cultural background. I know in certain parts of Western Africa, the man is the head of the place, of the marriage, and they make decisions. So a woman get up and say, I don't want to get married anymore. But the man is saying, oh, you're not leaving me. You are in the marriage, and you come to court with that situation. A child is not involved. How do you handle that?
Let me offer sort of a different perspective
Yes.
on that. One of the things as a district court judge that both Judge Sande and I get to do is we get to do a lot of weddings.
Okay.
And so
You get to do weddings?
yes, we get to do weddings.
We get to marry
Do you
people.
really?
Yes, we do. And then on the
And you do different language weddings too, don't
I
you?
do. And then on the other side of this, sort of, if you say our day job, we're dealing with the dissolution, so separating people, and then our night job, we're doing weddings, we're putting people together. And so what I tell people is I say, well, in order to get married, you need to have two people who are saying yes.
Right.
You need two people who say I do, two people who are agreeing to enter into the marriage. In order to have a dissolution, in order to have a divorce, you only need one person. Only one person has to say, I don't want to be married anymore.
So I'm married to somebody, and then I decide, I'm not getting married anymore. And then the man said, no, we are not from the United States. We are from Africa. We're going to stay together and we're going to be married. But the woman is saying, I just don't want to be married anymore. In this case, can you pronounce a divorce?
Yes.
Yes.
Tell me why.
Well, it's what the law is in Minnesota. I try not to be very flippant in a hearing with somewhere people are coming in, but I have had that where it's if people come in for a hearing and the case is not moving forward.
Right.
And we try to clear our cases in Hennepin County. We need to make room for more cases as they come through. And if someone says, well, I don't want to get a divorce, and it's like, well, they do, so that's all it takes. Next,
Right.
That's really it. But
I see.
you don't want to. There is a barrier there, and you can't be too cute about that, because if the underlying issue is domestic abuse, it raises a whole bunch of new issues. People. Hennepin County takes domestic abuse very seriously. We dedicate a lot of resources to it, both from the county attorney and from law enforcement and from the courts. Mm-hmm. And there's different levels of protection that people can get. We have a lot of victims advocates as well. If someone feels unsafe in their home, they're being controlled by somebody else, well, it's no way to live.
Absolutely.
We have an awful lot of laws that will protect the person, but it requires the person feeling comfortable enough to at least come to court and seek that kind of protection. Mm-hmm. If there's a child involved, what I tell people is that children learn about relationships from their parents and what they see. I've had a chance to meet Judge Browne's kids, and I know his wife, and I can see why the kids are doing so well, because they've got these great parents that they're being raised by. Mm-hmm. Michelle Obama gave a great speech in London a few years ago to a school, to a girls' school,
yes.
and what she was talking about how she became where she is, because she's not from a background that would you'd automatically, hey, she's going to be first lady. Right. And what she said is that it's because she was raised by a father and a brother, right, and met a man, President Obama, who all know what a respectful relationship between a man and a woman looks like.
Yes.
And when kids don't see a respectful relationship, how do you expect them to form one of their own? Right. So when I hear someone saying, this person can't get a divorce from me, that sounds disrespectful. Mm-hmm. And if there are kids involved, then what are the kids seeing at home? And so there has to be a way to engage the parties. I always tell people that if they're not ready to seek help for domestic abuse, that the courts are always here. No one's going to roll their eyes at them if they come back and say, well, you petitioned for these many times, you dismissed it. That's just how it goes. People need to feel comfortable for that. And if you see resistance from one side saying this person can't do it, well, how does that not raise flags to a judge? Right. That indicates to me that there's a level of control that's worrisome.
Right. You want to add to that?
Well, what I was going to specifically talk about is the children involved in that scenario.
Right.
So that level of control usually has a lot of conflict and a lot of fighting. And so again, exposing the children to that sort of
Environment.
environment, really the studies show decreases their health long term. And so it's even more critical, particularly if somebody is in the scenario where they feel as though there's a cultural bind that's there that is impacting the decision whether or not to stay in that situation. It's even more critical for that person to go and seek out the services that are there, whether it's through an advocate, whether it's through an attorney, whether it's through some of the other services that the courts provide. But it really also has just an immense impact on the long-term health of the children.
So the main point, the center focus is the children, because at the end of the day, it's going to mess everything up.
Well, the children are learning from the parents.
Parent.
So if the children learn that, well, if I go back to my example, well, it takes 2 yeses to get married. It only takes one
To
no
get
to get
divorced.
divorced.
To
Yeah,
get
I don't want to be
divorced.
married, right?
I'm not going to
Okay.
lose that one.
But if that lesson isn't learned in an appropriate way, you're perpetuating not only the situation that the victim is finding themselves in, but
Right.
also you're sort of creating generations of perpetration, and that's also a problem.
Right, absolutely.
Yeah.
When we have a criminal case where someone is being sentenced, we get from probation what's called a pre-sentence investigation. It's a long document, depending on what's going on, 10, 12, sometimes 20 pages long. Goes into everything with the defendant's background, education, the way they were raised, and all of that. And it's surprising to me how often in these pre-sentence investigations you that they were exposed to domestic violence as a child. And you can. I've always been curious about asking our research people what percentage that is, but you must have seen it a lot in the pre-sentence investigations you've read.
Yeah, there's the history of the family is really it's really informative and helpful to see what sort of services you're going to order for somebody who's involved in, let's say it's in a domestic abuse criminal type case, right? It's really helpful to get that information, and it's a great tool, and it's one of the things I think that helps us make sure that people don't come back, right? So in those scenarios, we don't want people to come back either on violations or on second or third or fourth cases.
Just 2 more questions. We have about 14 minutes left. I wanted to ask you, what can a client do if he or she is dissatisfied with your decision as a judge? And have you ever encountered problems like that?
Well, they can always appeal. They generally can try to get us to reconsider our decision. It would require some, I think for me, it would need to be some new information. Is there something that I didn't know at the time that no one could have told me about? What I do tell people is if I issue an order that they just can't comply with, they need to find a way to get ahead of that problem. They can come back and ask me to change one of the conditions. They can try to comply with it and say that I've been able to. I'd rather have that happen than someone just not follow the order at all, or just drop off the face of the earth and just leave it alone. But at the end of the day, what I tell people, because we try to be so engaged at the beginning of cases in family court, is there are tons of different tools that we have to try to help them solve the dispute themselves. Mediation, we can try to get them to resolve some of these things. We can send them to different classes, therapy. I can get more information for them. Lots of ways we can do to try to help them solve their dispute. If at the end of the day what they want to do is present it to me to decide, what I tell them is that I'll do that. That's my job. That's fine. Right. But you're rolling the dice, and you're having a stranger decide the most fundamental parts of your life. your family and your kids.
Right.
And if it sounds weird and unnatural, it's because it is. And it's a system we have, and we take facts and we apply the facts to the law. That's what we do. And if I think the law should have been written a different way, that's not really my job. I apply the law as it was written by the legislature and interpreted by the courts of appeal above me. But if someone is unhappy with my decision, there have been a number of ways along that path that they could have engaged to get out of that. By the time that I've issued my decision, if they're not happy with it, they need to look at, is there some way that can get me to reconsider it? That's a tall mountain to climb. Or take it up on appeal, or try to live with it a little bit and see if then they need to come back and look if I'll change it if it just hasn't worked for them. But Judge Browne has more experience with appeals than I have coming from civil court.
Well, no, I think you've definitely identified it correctly. I mean, the reconsideration typically is within 30 days. You can appeal an order, a final order, within 60. So those are main options for getting a different decision. And part of that is because in our courts, we need to be able to have finality, right? And so if we say, well, okay, here are the child support obligations. This is what you have to pay. You can ask me to take a look at that again, or you can go on appeal. But sort of at the end of the day, if you don't pay it, there are going to be some consequences, and you could find yourself coming back on a, in front of the court on a contempt, where the court's now saying, okay, why didn't you follow the order?
Right.
And then you could be looking at some jail time.
Jail time?
Yeah.
Oh.
Yeah, for contempt of court.
The penalties for non-payment of child support are severe. You can lose your driver's license, lose your professional licenses, and people can end up going to jail for non-payment of child support.
But all contempt issues. So anything, if the court finds somebody in contempt, the court has the authority to send somebody to jail.
It's not some important things.
Yeah.
Yeah. So, with all this explanation, do you think that they can ask for a lawyer? And if so, how do they, and can they also represent themselves in court?
Well, definitely. The parties who are coming to court, they have a right to go out and hire a lawyer if they'd like to hire a lawyer. On family court cases, we don't appoint lawyers. On criminal cases, we would. And fundamentally, you're not going to see appointment of lawyers unless what we're talking about is a liberty interest. And in cases where you're looking at contempt and the person could potentially go to jail, then there might be a scenario where there's an appointment of a lawyer. In criminal cases, you're looking at situations where it's the potential of being sent to jail or prison is what's triggering the right to have a representation, the right to have a lawyer, and that's where the court would then consider appointing a lawyer.
In family court, a lot of people represent themselves, and that's fine. They can choose to do that. I think they're better served with an attorney, most definitely. And the family court attorneys that appear in the Hennepin County courts are extraordinary. But, people don't work for free unless it's a volunteer lawyer, so I understand if someone has to represent themselves. The key thing for me then is if someone's representing themselves is to make sure that they understand what's going on and that it's perfectly fine for them to ask questions. So that, doing a trial by yourself without any legal training is a hard thing and it's scary. We try to guide them, but at the end of the day, if they've chosen to represent themselves and they're not going to they're not able to settle it themselves, they're going to have to try it themselves. We'll give them a lot of latitude, tell them how it works and all that, but that's more challenging. Up to trial, if someone is coming to a hearing, it's just key for them to understand that this is it's a formal proceeding. You need to know what's going on, but there's nothing wrong with asking questions.
Absolutely.
And we've got our self-help center at Hennepin County. There's a volunteer lawyers network. can always call and ask for help. If someone has a question about procedures in court, they can call our chambers. Now, our law clerks will not give them legal advice, but if they want to know that I've got a hearing coming up in front of the judge on this day, how do I get information to the judge? And they'll direct them to the self-help center and tell them how that can be done. But I think that people sometimes are afraid to ask questions in court, and there's no reason.
I think
why
the
they
reason
can't.
I think the reason why people are afraid of the court system is because they have this notion, like we talked about earlier, they're going to take my child away from me. So I'm just sitting in court and I'm just tensed. I don't know what the lawyer is going to talk about or the judge is going to say. I think it's breaking all these notions they have and, talking about what we're talking about, giving information to the public, let them know this is the structure, this is how it works. And if you play by the rules, this is what goes. And if you decide to represent yourself, you can represent yourself. Is that what I'm hearing? But it's difficult along the way, right?
Well, let me just make a couple comments about representing yourself. So the advantage of representing yourself, I think in Hennepin County, is the fact that we have a self-help center that has everything that you need to be able to get in front of the judge.
Right.
Okay, and so if that's your goal, is to get your issue in front of the judge, you're going to be able to get there pretty quickly with getting the information from the self-help center, getting the right documentation from the self-help center, being able to file the right motion, because part of what is inherent in the judicial system, in our court system, is due process. And due process is all about letting people know what it is you want to talk about and then having the opportunity to talk about it. And so if you say you want to talk about a school choice, right, and then you come in, you start talking about parenting time, right? Then that's where people start to feel frustrated, and sometimes when you're representing yourself, that might not be so immediately, might not resonate right away, but that can create some additional problems. So I think mainly what is really helpful is when people who choose to represent themselves also educate themselves about the process, educate themselves about what they need. Like Judge Sande is saying, ask questions that you have, and it's okay to ask them in the hearing, but understand that if you had an expectation, if you had an assumption about how things were going to go, and they didn't go that way, to not get frustrated about the process, but to get educated about it.
Gentlemen, we have 4 minutes left. I'd like you to, you know what has been going on. You've been seeing so many cases. It looks as if family court system and criminal system is pretty interesting because we've really touched on a lot of things. I'd like you to take a minute, both of you, and tell the public something. Whatever you want them to know.
Well, I think the key is that people need to understand that they're the ones who fund the court system. We all serve on the ballot for election at some point. We're also appointed by people who've been elected. The key is that there is no reason that they can't be engaged in the system. There's no reason that they can't ask questions. Look, we are state court judges. We are the direct connection between the people and the courts. This isn't the Court of Appeals. This isn't federal judges. We are dealing with people in their everyday lives. And the Hennepin County court system, as Judge Browne has said, has created so many different avenues to try to help people get their positions into court, because the alternative, if they don't solve their disputes in court, is you have people getting baseball bats and guns and dealing with things on their own, and that's just no way to have a society. I tell people when they come into court, if they're going to represent themselves, we don't do trial by ambush. You have to tell the other side what you're going to present and what you're going to do, and then I'll let you do it. I'm not going to let them ambush you either. And if you want to communicate with me, you've got to go through the court system, because how will you feel if if you find out later the other side was contacting me?
Absolutely.
So we keep it an open, fair playing field, and we give people a chance to tell us what they think, because we want to decide these cases on the merits after we've heard from folks. And they really shouldn't be intimidated or frightened by the system. If staff is rolling their eyes and treating people badly, we want to hear about it. I've not heard that. Our staff here is incredibly patient.
Thank you so much. Judge Browne, you want to take a minute?
Yeah, I think one of the things that's helpful to understand is that the court system is really that place to resolve disputes. And so I think, first of all, recognizing that you have a dispute that you cannot resolve between you and another person, whether it's a civil case, whether it's a family court case, whether it's a probate case, recognizing that you need the help to resolve that problem and that we're here to do that. Our fundamental role is to hear the dispute and make a decision on it. And the more information that you provide to us to be able to make that decision, quite frankly, the better the decision it's going to be. Now, it might not be the decision that you thought you were going to get. And that's why all throughout the various stages of a case, we may be nudging here and there to say, have you considered mediation? Have you considered another way? Have you considered sitting down with family court services and seeing if you could work through the parenting time, the custody issues? Part of that is because the decision that the two parties, or three, come to, the decision that they themselves agree to, where there is concessions on both sides, is usually the decision that people are going to be able to live with the most. When we have to make the decision, when we have to step in and say, okay, you're stuck, we are going to decide, that's giving away your ability to participate in it fully. And you're giving that decision, that really important decision, as Judge Sande was saying, that's your family, that is your children, you're giving those decisions away. And you don't have to do that if you're able to resolve it through our system.
Absolutely.
Yeah.
Well, gentlemen, it's been amazing having you too. Thank you so much.
Thank you.
Thank you. Thanks
Thank you.
very much.
Thank you.
Thank you. I can't wait for the next topic next week somewhere. With that said, good night and thank you very much. Oh, it's really interesting to know that you marry people and then you divorce them.
Right.